me.
What you have filed through the clerk's office, you're saying are matters in equity. We don't recognize what you're talking about in these filings.
This is a bank. This is a bank. I understand how the
What'd you say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This court system doesn't operate like a bank in any way whatsoever.
Hold on, let me finish.
No. I'm not going to let you finish that particular. I think it's appropriate for me at this time now to terminate the Faretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement, including raising nonsensical challenges and attempting to apply commercial law to criminal prosecution or equitable law.
No, that's not
ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it.
And it states that should a man prove himself to be living and not dead, nor loss of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executor. As such, this office give notice of its accusations and finding.
I want to note a couple things for the record. Ms. Butler, I received a pro se filing from you yesterday. There were some documents and things mailed to the court. Do you recall doing that? You recall sending this to the court?
I sent it to the young lady, yes.
Okay, so I am going to scan this, put it up into your file, but I just want to note for the record that we don't permit what's called hybrid representation, okay? So you have counsel, you can't also submit matters on your own behalf. Anything you want to submit to the court, you have to submit through your attorney. Do you understand that?
Yes.
You do understand that?
Yes.
Okay, and then the matters that you submitted aren't matters that we understand in this court. You submitted what we refer to as pseudo-legal jargon or matters that are contractual in nature and have nothing at all to do with a criminal court case. So I'll upload them into the case, but I'm also going to strike them from the record. Okay? Just so you're aware.
Mail that to the clerk. I didn't mail it to, that's private that you have, the documents that you have.
Do you have another case pending somewhere in the court system other than this one?
It's just this case here. Those was private documents. It wasn't for public only.
Is this something you want to file with the clerk?
No, it wasn't filing with the court. No, it wasn't supposed to file with the court. It's supposed to file with the head clerk, Jessica.
And are you trying to file a case or something other than in this case?
It's referring to this case, yes.
Okay, so we'll upload them into the file and strike them from the record, as I mentioned. Let's get a trial on the calendar. Mr. Prosecutor, how many days you need to try this case?
Judge, I believe 2.
Let me say something. Because I'm not being represented and I'm not, my evidence is not being presented like it's supposed to be. Yeah, because you're not helping me. Would I be able to say something? Okay.
All set. Trial by jury on August 18th and 19th. So, Ms. Butler, I set you over for a jury trial on August 18th and 19th, 2026. If you fail to appear for your jury trial, I'll hold it in your absence, and you can be convicted even if you're not present. You understand that?
I comprehend.
We're adjourned.
Your Honor, before we adjourn,
Can you grab the mic?
Before we adjourn, Your Honor, I know Ms. Butler wanted to make a statement if court would allow that.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that happen towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one want to listen. Everybody's being selective-minded, and I just want to address that to the court. I have so much evidence that I have presented in this court to show you, to prove to you, show facts, and also show you there's a lot of concealment within this court. So I'm asking you Can you adjust somebody to assist me in that matter?
Ma'am, we appointed the Porter County Public Defender Service, I believe, to represent you. Are you in this matter privately, Mr. Pribble?
No, I'm not.
So we appointed the Porter County Public Defender Service to represent you, ma'am. I appoint them and then they appoint a lawyer. So you've got Mr. Pribble involved in the case. You can't pick and choose what lawyer you get when you ask the court to appoint counsel for you. You get what you get.
I get that, sir.
Okay?
But only thing, the reason why I ask is because I feel like I'm not being helped. I see like I can do it myself and present this as pro se, but evidently it's just being delayed continuously.
Well, ma'am, if you want me to do what's called a Faretta hearing and make a determination of whether you can represent yourself without counsel, are you prepared to do that?
Yes, I am, sir.
Okay, I mean, I can do that Faretta hearing, but I'll let Mr. Pribble go for the day and I'll hold you until we're completed with the rest of our business. I'm not gonna make all these other people wait while I go through a Faretta hearing with you.
Can I come back?
Come back when?
What time is it? Around 12:30?
Oh, no, ma'am. I don't have time at 12:30, but I have time around 11:30. Did you have a chance to review the pro se waiver rights form I presented you in open court?
I looked at it a little bit.
Did you sign off on that?
No, I did not sign off on it yet.
Okay, would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I have written on the back of it. You have
I'll give you a whole
a
new-
spare. I'm just gonna give me a whole new one. Can I also address something? You just let me know when I can.
Go ahead.
When we spoke earlier about the document.
Things get even more interesting when the discussion shifts to equitable law and jurisdiction arguments. The judge repeatedly explains that criminal court follows criminal procedure, not commercial or contract law theories. This is a critical distinction because using the wrong legal framework can seriously damage a defense. The defendant insists he's learning as he goes, but the court wants evidence of actual legal understanding.
The document that was submitted, I just want to inform you that the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So I was going to let you know that my estate has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So, for that being said, I'm coming here with honor, clean hands, and no controversy. I do not want to argue about anything. I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? How this all led up to, because I really never got a chance to even speak to no one. I've been
Ma'am,
silent.
that's what the jury trial's for, okay? All the facts and circumstances related to the case, the state's evidence, everything of that nature would come out during the jury trial. So I need to go through this Faretta hearing with you, ma'am.
Okay.
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty, 2 level 6 felonies. So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court.
I comprehend that.
Okay. Attorneys have developed certain skills in, an attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend that.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. Do you understand that?
Yes, I comprehend that, so.
Okay.
The tension rises when the defendant says he believes the judge is an actor. At this point, the court appears increasingly concerned about whether he understands the legal process. Judges must ensure defendants make informed decisions before allowing self-representation. If a defendant doesn't grasp basic legal concepts, the court can step in to protect the integrity of the case. This exchange may have just changed the outcome of today's hearing.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations, findings regarding Porter County Superior Court interaction with Tierra Lene Butler. You talk about final order to settle and close,
Yes.
different things like this.
Yes.
And then there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that I had in a high.
That's not the question I asked.
No.
I think you misunderstood the question.
It's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand
Yes,
that?
yes, I am in a criminal proceeding, but like I've been trying to explain, ever since when I had.
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you follow with the clerk's office, what's the receipt date on this?
It should be April 16 or 15.
April 16th it was received, so just yesterday.
Mhm.
That these aren't criminal matters that you followed with the court?
Those are criminal matters, the violations that have been held against me. Yes, that's a lot of violations.
You understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah,
some
that's
sort of
what
a
we-
pseudo-legal jargon, some type of
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is the
Means
Superior
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. What I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself, but what I'm saying is I have done some research, okay? And I actually wanted to address it, and I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a brand new violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Faretta hearing.
I know, but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are.
part of this court proceeding.
Now, on this court proceeding.
If you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have an attorney.
I did that too. You know what he did?
I don't know, man.
Ignored me.
Now we're reaching the heart of the judge's decision. The court points to previously rejected filings and repeated misunderstandings of criminal procedure. Self-representation is a constitutional right, but it comes with strict responsibilities. A judge can deny that request if it's likely to disrupt proceedings or prevent a fair trial. The ruling is about legal competence, not personal confidence.
Particular statement.
I said, I want to
You just-
preface
just
this. Don't
need-
want to argue.
I need you
anything.
to,
I just want you to
redirect it.
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes. Yes. Yes.
You will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a minute.
Yes. It's a difference.
What's the name of the clerk's office?
The court's office is the clerk of clerks. Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own.
No.
Okay.
What I am.
This has to be presented in your court case here that you have pending before us.
Okay.
you're
So you
trying
will
to
not strike
follow
it?
the Rules.
You won't strike it down or you will strike
Oh,
it?
it has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
How you
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay.
You realize
But-
that?
But let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
What I also want to say something, and I also am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive. As such, this office gives notice of its authorizations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executive. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon and administrating it. I discovered a lot of things along the way, put me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Faretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No.
and attempting to apply commercial law to criminal prosecution
No.
or equitable law.
No, that's not
Ma'am, you keep
true.
saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned.
In the end, the judge denied the request for self-representation and kept appointed counsel on the case. The court concluded that the defendant lacked the legal understanding required to proceed alone. Future filings must now go through his attorney rather than directly to the court. It's a powerful reminder that courtroom rules matter just as much as courtroom arguments.